Isang mambabatas sa Pilipinas noong Biyernes ang nagsabi na nababahala siya sa pahayag ni Chief Justice Alexander Gesmundo na tila nagpapahiwatig na ang 203 bilyong state tax case ng pamilya ni Pangulong Ferdinand Marcos Jr. Nabatid sa ulat ng Inquirer na noong Miyerkules sinabi ni Gesmundo na walang desisyon ang nakalagay sa bato. Nang tanungin kong ang mga kaso na napagdesisyonan ng may katapusan tulad ng sa mga Marcos ay maaari pa ring muling buksan. Sinabi ni Albay Representative Edcel Lagman na alarming ang pahayag ng punong maestrado. Paliwanag niya, ang pahayag na iyon ng maestrado ng Korte Suprema ay talagang abundonahin ang isang maayos na prinsipyo ng res judicata o ang conclusiveness ng paghatol kapag ang isang bagay ay nalutas na o hinatulan ng isang karampatang hukuman na may finality, ang mga partido ay hindi maaaring magpatuloy sa anumang karagdagang opsyon. Sinabi rin ng mambabatas na labag sa doktrina ng lashes ang hakbang. Ayon kay Lagman, na ang muling pagbubukas ng kaso ng buwis sa ari-arian ni Marcos ay maaaring magtakda ng isang president na gagawing walang katapusan o walang katapusan ang mga paglilitis sa bansa. Binigyang diin din niya na ang kaso ng Marcos estate tax ay matagal lang nilitis. Sinabi ni Marcos Jr. na dapat buksan ang kaso ng buwis ng kanyang pamilya matapos magpadala sa kanila ang Bureau of Internal Revenue ng demand letter para bayaran ang kanilang estate tax na lumubog mula humigit kumulang 23 bilyon noong 1997 hanggang 203 bilyon. Dagdag pa ni Marcos Jr. na makikita sa isang post sa social media, "We were never allowed to argue because when this case came out, we were all in the United States. So when it was the time for us to answer, we had no chance to answer because we were nakakulong o detained in the Highcam Air Force Base." President Ferdinand Marcos Jr. claimed in an interview with actress Tony Gonzaga that aired on September 13, 2022. Sinabi ni Lagman, gayon pa man, na ang pinakamagandang bagay na magagawa ngayon ni Marcos ay magbayad ng buwis ng kanyang pamilya.
Now, to get his thoughts on this issue, we are joined this morning by Albay Representative Edcel Lagman, who is also a veteran human rights lawyer. Congressman Lagman, good morning. Welcome back to the program.
Hi, good morning, Mike.
All right.
Thank you for this opportunity.
All right, Congressman Lagman, you were among the first to react to the remarks made by Chief Justice Alexander Gesmundo during a Kapihan sa Manila Bay Forum on Wednesday. What for you was alarming about his comments that prompted you to issue a statement?
Well, it was alarming that the Supreme Court, to the Chief Justice, may simply grant the reopening of the Marcos case on the estate tax, because that statement of the Supreme Court Justice would really abandon a well-settled principle on res judicata, or the conclusiveness of judgment. When a matter has been resolved or adjudicated by a competent court with finality, the parties cannot pursue any further action. And that is the essence of res judicata. And at the same time, the doctrine of laches, when a party does not take any action due to lack of diligence to claim a legal right, then time would set in to prevent such party from resurrecting or claiming such right at a future time. So, and another is the public policy that litigation must end. In this case, if final decisions can be reopened at any time, then litigations would be interminable or endless, and that would be a violation of these principles I have just stated. In the case of the Marcos estate, that case had been litigated for so long already. The Marcoses went to the Court of Appeals. The claim was rejected. when the Court of Appeal said that the assessment was already final and there was failure on their part to make a seasonable appeal, it went to the Supreme Court. The Supreme Court said the Court of Appeal's decision is final and that cannot be any more revoked, and it is unappealable. Then they filed a motion for reconsideration before the Supreme Court. Again, the Supreme Court denied the said motion. Then they filed a second motion for reconsideration, which is supposed to be a prohibited motion. And again, the Supreme Court said, no, the decision is now final. Until the Supreme Court issued on March 9, 1999, that the decision on the tax assessment in the amount of 23 billion, which has ballooned to 200 plus billion, is final and unappealable. That was the statement of the Supreme Court. And the Marcoses were given enough time to challenge the final assessment. And most probably in these cases which they have filed, they've already articulated what they wanted to say in their defense. And after more than a quarter of a century, almost a quarter of a century, I don't think this case can be reopened. The cases cited previously were reopened soon after the decision became final, and there were good grounds to have the case reopened. The motions for reconsideration filed by the Marcoses, as well as their petition before the Court of Appeals and the Supreme Court, gave them that opportunity to ventilate their position, and they were all junked or denied by the judiciary. So
we'll get to that.
There is no point now. I think there was some lack of understanding, most probably the Supreme Court justice was misquoted, because there should be a difference between jurisprudential doctrines being reviewed, rejected, or modified in subsequent similar cases, but not in the same case, where the verdict had already become final. And these are doctrinal statements of the Supreme Court in one case and later on reversed in another case. But this is not the same as in the case of the Marcoses being reopened, because this is the same case where the verdict has long become final and executory.
Congressman, to be fair to this Chief Justice, he was stating in general terms about the reopening of cases. He didn't specifically mention the Marcos case, but he cited two cases where supposedly the trial was reopened due to violations of due process. And these are the cases of Galman versus Sandigan Bayan and Fabian Ver case, where supposedly because of violations of due process, the Supreme Court reopened their case and retried it. What do you make of these cases cited by the Chief Justice? Do you think these cases are applicable to the Marcos case?
Well, I would say that these cases may not be applicable because, one, the reopening, quote unquote, of the said cases were done soon after the final decision, or not through a lapse of time. Number two, the Marcoses were already given the opportunity to reopen the case when they filed a petition before the Court of Appeals, when they filed a petition before the Supreme Court, and when they filed motions for reconsideration. These were all due processes given to them, and the courts denied their position, denied their petition. That reopening, so-called, has already happened, and a case should not be reopened in perpetuity. Otherwise, we would have endless litigation. The public policy, again, is litigations must end in time.
Congressman, on another point, can the Supreme Court still reopen the issue of denial of due process when that was the very issue that the Supreme Court settled in its June 1997 decision, which became final and executory in 1999. The court said the Marcos family did not file a protest within 90 days from the receipt of the tax assessment. And let me just quote portions of that ruling. The subject tax assessments have become final, executory, and enforceable. The same can no longer be contested by means of a disguised protest. In the main, certiorari may not be used as a substitute for a lost appeal or remedy. And to continue, Congressman, we cannot therefore countenance petitioner's insistence that he was denied due process, where there was an opportunity to raise objections to government action, and such opportunity was disregarded for no justifiable reason. The party claiming oppression then becomes the oppressor of the orderly functions of government. So those are the clear words of the Supreme Court in that 1997 ruling. Can they still discuss the issue of denial of due process in another case or in the reopening of this case?
I don't think so, because that decision is already final and executory. And in that decision itself, it says that the Marcoses were given due process, but their claim of a late appeal could not anymore be entertained, considering that the decision has become final way back in the decision of the Court of Appeals, way back in the assessment made by the Bureau of Internal Revenue. So what other claims will the Marcoses put up in reopening the case when the same claims and same arguments had already been articulated before the courts, and the courts junked these claims no less than the Supreme Court itself?
What do you make, though, of the statement of Chief Justice Gismundo saying that it really depends on the composition of the Supreme Court? He likened it to the situation in the US, where there are liberals and conservatives, and somehow the numbers will matter. Wasn't he just being practical? Because, to lawyers who are litigating before the Supreme Court, they know it's a numbers game. It depends on the vote of the magistrates. But what do you make of this statement coming from the Chief Justice himself?
Well, I think he was referring to jurisprudential doctrines of the Supreme Court, whether in the United States or in the Philippines, where subsequent composition of the court, because of the liberal or conservative temperament of the justices, these doctrines can be abandoned, can be modified, but it will not be tenable with respect to a case, the same case which has become final and executory. He was referring to subsequent cases before the Supreme Court where doctrinal pronouncement is questioned, and the Supreme Court, because of its new composition, can, will, and in many cases have abandoned these doctrines because there should be no blind adherence to precedents. But but you know that, Mike, that is a principle in law. But I think the Chief Justice was misunderstood. He was referring jurisprudential doctrines being abandoned or modified in subsequent similar cases, but not in the same case which has become final and executory.
So what then should the government do at this point? Do you agree with the opinion of former BIR Commissioner Kim Enares that the BIR should file a new case to collect the 23 billion peso estate tax liability, which some have estimated to have ballooned to 203 billion pesos?
It's the call of the BIR to really collect and implement a final and executory decision of the court. It is not anymore within the judicial department. It is now within the executive department through the BIR to make this necessary collection of these unpaid taxes.
And should the BIR file that case, can the Marcoses still challenge the amount being collected by the BIR? There are some issues as to whether 203 billion pesos is really the proper amount. But in the 1997 ruling, it was clearly stated 23 billion pesos. So with respect to that amount, 23 billion pesos in the final and executory ruling of the Supreme Court in 1997, can the Marcoses still challenge that amount in a subsequent case?
Well, I don't know what subsequent case is being talked about.
Mhm.
because the case has been settled. All
For
that
the collection case that the BIR will file.
I
supposedly.
can collect without filing any case because the case is already settled. Otherwise, if you file another case, then that will be reopening the case. That's directly reopening the case. So I think the BIR should enforce and implement the decision which is now final and make the necessary connections.
And Congressman, if you were the Marcoses, what will you do at this point?
Well, if I were the president now, and I would have to comply with a final decision to tell the people that I submit to the rule of law, and to tell the people that taxes are the lifeblood of the nation, and taxpayers should pay their correct taxes.
On that note, thank you so much for joining us this morning and for sharing your insights with us, Representative Edcel Lagman.
Thank you, Mike.